A private copying levy is a government-mandated scheme in which a special tax or levy is charged on purchases of recordable media. Such taxes are in place in various countries and the income is typically allocated to the developers of content. Levy's system may operate in principle as a system of collectivization, partially replacing a property approach of sale of individual units. History: such levies were first introduced in Germany in the 1960s. With the advent of the audio cassette, legislators were persuaded that cassette recorders would decimate sales of records as friend after friend would then make copies of only one purchased album. Levies today are assessed on recordable compact discs, a form of media that did not exist when levies were first conceived. Although the bulk of unrecorded compact discs are actually used in the computing industry, they are still taxed to provide a revenue stream to the recording industry. Levies are often considered a compensation for illegal file sharing. This is debatable, however. Levies could be seen as not being an advance for fines, but rather, only intended to compensate for copies in the private sphere that are legally allowed in many jurisdictions. A notable exception in Europe is the UK, that does not allow private copies. But generally legislators allow private copies for two reasons: firstly, because otherwise the enforcement would be unfeasible for private reasons, and secondly because the administrative burden would be disproportional. European Union Review Ontario, 2015-07-09. The European Parliament approved a non-binding resolution asking a review of the levy in the European Union, building on previous resolutions and studies. Questions on fairness. A difficulty that immediately arises is the practical impossibility of devising a mechanism for distributing the proceeds to copyright holders that is considered fair by all copyright holders and consumers. Implemented systems are typically restricted to music and may distribute the proceeds proportionally to a measurement of sales of CDs in music shops or amount of airplay on radio or the like. This ignores other distribution channels such as the Internet, and it disproportionately benefits popular artists and publishers of the related products. Fairer methods would arguably involve extensive sampling of purchases to determine actual recording behavior, or alternatively paying all musicians at a simple flat rate. While the prime purpose of levy systems is to compensate authors, some part of the collected money is also used for general cultural funding purposes. In Germany this is even required by law. It acknowledges the purpose of cultural diversity, which is not necessarily identical to free market effects. This funding is usually executed by the same entities that distribute the levy money to individual authors. One may question, however, whether these entities are properly qualified to make culture policy. Levy systems assume that all authors want to exploit their work for money. However, this is not always true, especially on the Internet. Many authors do not write to entertain, but to inform readers, listeners and viewers. Often their purpose is to reach the widest possible audience rather than make the maximum profit from the copyrighted work by itself. The discrepancy between reality and the assumption underlying a levy system is growing as Web 2.0 matures, with pervasive user-supplied content, from Wikipedia to YouTube. A further problem is to find a proper tariff base for levies. Conceivably the levy may be a percentage of storage media sales price. The implication of such a scheme is, however, that the author gets ever less as technology proceeds and becomes less expensive. But a price based on units of information is not fair either, as for instance a DVD can be used to store a film, a computer game, a large amount of documents, or measurement data. The cost of producing a certain amount of bits widely varies by type of information. Measurement data is even not copyrighted at all. Yet in today's world of converging technology, storage media can be used for a wide range of purposes. An implementation question that arises is whether the tax applies to any type of copyrighted work or is restricted to a limited field such as music. If it is restricted, then the issue arises of how to collect the tax on media which can also be used for other purposes. The options include collecting the tax on all media, regardless of the end use, and ignoring the injustice to purchasers with non-covered uses. Allowing taxed and untaxed media to be sold, but with only the taxed media providing the copyright relaxation benefits. collecting the tax on all media but allowing purchasers to claim a refund for media applied to non-covered users. Contrary fairness arguments. Although these complexities make the systems of levies far from perfect, they do have some advantages related to fairness in that since there is compensation for private copying, whereas in countries where there is no levies, there is a substantial amount of copying taking place without any due compensation being made. With respect to fairness in countries with the levy, everyone shares in the financial burden caused by the levy. In countries that do not have the levy, many people are copying music and never receive any reprimands, while others are made an example and prosecuted. This is the similar argument that non-proponents to the levy system use to show fault. They advocate that if the levy cannot be precisely applied to the people that are private copying, it is a faulty system. Likewise, if one cannot reprimand all people that are copying illegally and not compensating the music industry, this is also a faulty system. One system oversubscribes, the other undersubscribes, both are false. Finally, those countries that do not have private copying laws are in fact making many of their citizens criminals. A law which makes potentially more than 50% of the population criminals does not seem to be a fair business practice. Lawyers rather than artists may well be the greatest beneficiaries in non-private copying countries. This argument assumes that private copying can only be allowed with a levy. Legal effects. It is theorized that such levy may be linked to a corresponding relaxation of copyright law, by permitting the recording of copyrighted works on media for which the tax has been paid. However, there is little evidence to support this theory. On the contrary, lobbyists representing publishers and copyright holders have increased pressures to implement more restrictive laws, even on countries that have implemented private copying levy. In 2007, it was reported that International Intellectual Property Alliance put 23 of the world's 30 most populous countries into priority watch list, even though the United States, which was not in the list, has laws that are more liberal than the laws from the countries within the list. Even when restricting levy system to devices that primarily play music, this itself creates loopholes that prevents collecting levies from cell phones, PDAs, and other all-in-one portable electronic devices. As a result, copyright holders will have to rely on even more laws to collect levy, and to increase rates of already levied product to recover perceived losses, which run against the political trends toward eliminating levy systems. Regulations. Examples of countries operating such schemes. Australia Australia has a public levy on cassette tapes. The legislation establishing the levy was passed in 1989, challenged in the High Court of Australia in Australian Tape Manufacturers Association Limited v Commonwealth. The court found the tax legal even though it went to private sources because it served a public purpose. Belgium In Belgium a fee is charged on both blank media and recording equipment which is passed on to Attribution, which is in charge of distributing the funds. As of February 1, 2010, these fees are applicable for the following: equipment with integrated carrier, MP3/MP4 player, cell phone with MP3/MP4 functionality, capacity is less or equal to 2 GB, a 1.00, capacity is higher than 2 GB and less or equal to 16 GB, a 2.50, capacity is higher than 16 GB, a 3.00. TV, hi-fi, combined DVD writer and video recorder, multifunctional DVD home cinema, set-top box, multimedia center, capacity is less or equal to 256 GB, a 3.30, capacity is higher than 256 GB and less or equal to 1 TB, a 10.75, capacity is higher than 1 TB, a 13.00. Non-integrated equipment with integrated carrier, DVD recorder, DVD reader, CD writer, video recorder, DVD home cinema, capacity is less or equal to 256 GB, a 3.30, capacity is higher than 256 GB and less or equal to 1 TB, a 10.75, capacity is higher than 1 TB, a 13.00. For the following equipment, without integrated carrier, that are not integratable in a computer and work standalone, have a fee of a 2.00. Hi-Fi with radio cassette CD, combined DVD writer and video recorder, combined DVD reader and video recorder, portable radio cassette recorder, combined portable radio cassette CD, TV and combined DVD writer, DVD recorder, cassette deck, video recorder, CD writer, minidisc writer, CD audio to minidisc writer. Digital carriers, memory stick, memory card, capacity is less or equal to 2 GB, a 0.15, capacity is higher than 2 GB and less or equal to 16 GB, a 0.50, capacity is higher than 16 GB, a 1.35. External hard drive, capacity is less or equal to 256 GB, a 1.30, capacity is higher than 256 GB and less or equal to 1 TB, a 6.75, capacity is higher than 1 TB, a 9.00. Blank CDRRW, mini CDRRW, mini DVD-RRW, minidisc, audiocassette DAT, a 0.12/disc, blank DVD plus RW, a 0.40/disc. Analog carriers, audiocassette, audiotape, videocassette 8mm, a 0.12, videocassette, a 0.40. Canada A blank media levy was introduced in Canada in 1997, by the addition of Part 8, Private Copying, to the Canadian Copyright Act. The power to set rates and to set the distribution allocation is vested in the Copyright Board of Canada. The Copyright Board has handed the task of collecting and distributing the funds to the Canadian Private Copying Collective, which is a non-profit private organization. In Canada, the levy applies to blank audio recording media, such as CDRS. The levy is paid by importers and manufacturers of such media sold within Canada. With the exception of the zero rating exemption, the levy is collected regardless of the purchaser's end use of the media. The private copying levy is distributed as per the Copyright Board's allocation as 66% to eligible authors and publishers, 18.9% to eligible performers and 15.1% to eligible record companies. The Canadian Private Copying Collective has developed a methodology by which the proceeds are distributed to rights holders based on commercial radio airplay and commercial sales samples, ignoring radio college airplay and independent record sales not logged by SoundScan. This methodology has been criticized as favoring major label artists at the expense of the long tail. As of September 7, 2007, over $100 million has been distributed. In conjunction with the levy, the Copyright Act allows individuals to make copies of sound recordings for their own private, non-commercial use. They may not distribute the copy. In 2005, the Federal Court of Appeal overruled a 2003 Copyright Board decision which had applied the blank media levy to MP3 players such as Apple Incorporated's iPod, on the basis that such devices did not qualify as audio recording medium as per the Copyright Act definition. Before this, the proposed rates were $2 for players with less than 1 GB of capacity, $15 for players up to 15 GB, and $25 for players 15 GB and over. On February 12, 2007, CPCC asked the Copyright Board of Canada to reintroduce the levy of $5 to $75, this time onto the memory component of the digital audio recorders in Canada. 1. In addition, CPCC also proposed levies of $2 to $10 for memory cards, 8-cent increases to CD, CDR audio, CDRW audio and mini-discs. 2. Certain parties objected to this tariff based on the 2005 Federal Court of Appeal precedent and brought a preliminary motion before the Copyright Board that would have prevented that part of the tariff application from being considered. The Copyright Board dismissed this preliminary motion in July 2007. In September 2007, an application for judicial review was brought before the Federal Court of Appeal to appeal the Copyright Board's dismissal. On October 26, 2007, the court granted the Canadian Recording Industry Association's request to intervene in the private copying iPod levy judicial review. 3. Some argue that CRIA wanted to limit the scope of the private copying levy, given that it legalizes copying for the private use of the person making the copy, possibly regardless of whether the source is non-infringing or not. 4. In January 2008, the Federal Court of Appeal overturned the Copyright Board's July 2007 decision, stating that its previous ruling in the 2005 Canadian Private Copying Collective v. Canadian Storage Media Alliance case is dispositive authority for the proposition that the Copyright Board has no legal authority to certify a tariff on digital audio recorders or on the memory permanently embedded in digital audio recorders. 5. Canada's current private copying levies are as follows: 24 cents per unit for audio cassette tape, and 29 cents per unit for CDR, CDRW, CDR audio, CDRW audio and minidisc. The Pirate Party of Canada, or the PPCA, has recently brought up the idea of scrapping the tax, as there are plenty of non-piracy related uses for CDs and it is unjust to punish Canadians who don't use them for these purposes. Finland Finland had a blank media levy 1984 to 2015. From 2015 on, the funds come directly from the state budget. As of beginning of 2012, the fees were a 0.005 per minute for analog audio tapes, a 0.0076 per minute for analog video tapes, a 0.20 per disc for CD and minidisc, a 0.60 per disc for DVD, DVD-RAM, DVD-RDL and DVD plus a DL, a 1.20 per disc for Blu-ray disc and HD DVD, a 1.80 per disc for Blu-ray disc and HD DVD, a 4 to a 36 depending on capacity of digital audio players or personal video recorders. A 4, memory up to 512 megabytes, a 7, over 512 megabytes to 1 gigabyte, a 10, over 1 gigabyte to 20 gigabytes, a 12, over 20 gigabytes to 50 gigabytes, a 15, over 50 gigabytes to 150 gigabytes, an 18, over 150 gigabytes to 250 gigabytes, a 25, over 250 gigabytes to 500 gigabytes, a 30, over 500 gigabytes to 750 gigabytes, a 36, over 750 gigabytes, a 5 to 18 for external hard disk drives, a 9, over 50 gigabytes to 250 gigabytes, a 12, over 250 gigabytes to 1 terabyte, an 18, over 1 terabyte to 3 terabytes. Smaller and bigger drives have no levies. There was no levy fee on mobile phones, computers, memory cards, game consoles, USB flash drives and 8 cm CDs DVDs. VAT of 9% is added to the levies. Germany The world's first private copying system was created in Germany in 1965. It was a result of earlier successful litigation by GEMA against an audio equipment manufacturer and GEMA v. Grundig. Luxembourg Luxembourg is the only EU member state on the continent without a private copying levy, making it a popular e-copying levy haven euro for blank media buyers from countries such as France and Germany. Netherlands In the Netherlands, a fee is charged on blank media which is passed on to Stichting Thwiscopy, which is in charge of distributing the funds. Fees for February 17, 2007 until January 1, 2010 are as follows. Data CDRRW, a 0.14 per disc, audio CDRRW, a 0.42 per hour, blank DVD-RRW, a 0.60 per 4.7 GB, blank DVD plus RRW, a 0.40 per 4.7 GB, blank DVD RAM, exempt, video analog, a 0.33 per hour, audio analog a 0.23 per hour, minidisc, a 0.32 per hour, HIMD, a 1.10 per carrier. Portugal established a levy on CDs and DVDs in 1998. Russian Federation Article 1245 of Civil Code of Russian Federation. Remuneration for free reproduction of phonograms and audio-visual products for private purposes mandates a fee, which is to be distributed in the following proportion: 40% to the authors, 30% to the singers, 30% to the manufacturers of the media. In practice, this fee had not been charged until after the regulation of the Government of Russian Federation 829 from October 14, 2010, which mandated a uniform 1% tax on computers, blank optical discs, memory sticks, TVs, video and audio recorders, radios, mobile phones, etc. The controversial decision of the government to award the collected funds to the Russian Union of Rights Holders for further distribution was criticized by the public and disputed in a lawsuit. Sweden equals. In Sweden there is a fee called privatkopieringskurrency ttning, earlier called kassettskurrency ttning, on compact cassettes, blank CDs, blank mini-discs and other storage media. As of September 1, 2011, this fee will apply to external hard drives and other USB storages as well. The fee is 2.5 a paragraph read per minute of storage for analog media or 0.4 a paragraph read per MB for re-recordable media or 0.25 a paragraph read per MB for write-once media. The money collected is handled by Copy Swede. Switzerland equals, tax on recordable DVD, 0.36 Swiss francs per recordable DVD, 1 Swiss franc per rewritable DVD, 0.38 Swiss francs per 25 GB on HD discs. Tax on digital storage media such as microchips or hard drives in audio and audio-visual recording devices, memory capacity up to 4 GB, 0.70 Swiss francs per GB, memory capacity between 4 GB and 8 GB, 0.65 Swiss francs per GB, memory capacity between 8 GB and 16 GB, 0.50 Swiss francs per GB, memory capacity between 16 GB and 32 GB, 0.38 Swiss francs per GB, memory capacity over 32 GB, 0.30 Swiss francs per GB. Compensation for the transfer of use of set-top box with memory and BPVR, 1 Swiss franc per month and subscriber if the following charges do not apply, 0.13 Swiss francs per month and subscriber if free or part of the basic package, 0.55 Swiss francs per month and subscriber for monthly subscription fee up to a max of 6.50 Swiss francs. Tax on digital memory and cell phones, 0.30 Swiss francs per GB. United States equals. Audio home recording in general, 17 U.S.C. A Section 1008, as legislated by the Audio Home Recording Act of 1992, says that non-commercial copying by consumers of digital and analog musical recordings is not copyright infringement. Non-commercial includes such things as resale not in the course of business, perhaps of normal use working copies which are no longer wanted. It is unlikely to include resale of copies in bulk. Napster tried to use the Section 1008 defense but was rejected because it was a business. From House Report No. 102 to 873, September 17, 1992, in the case of home taping, the Section 1008 exemption protects all non-commercial copying by consumers of digital and analog musical recordings. From House Report No. 102 to 780, August 4, 1992, in short, the reported legislation, Section 1008, would clearly establish that consumers cannot be sued for making analog or digital audio copies for private non-commercial use. The United States music industry administers the Audio Home Recording Act and foreign home taping royalties for artists on U.S. sound recordings as well as U.S. record labels. These royalties are administered by the Alliance of Artists and Recording Companies for featured artists and copyright owners, ASCAP-CESAC for writers, Harry Fox Agency for publishers, and the AFM-AFTRA Intellectual Property Rights Distribution Fund for non-featured artists. All societies also collect foreign remuneration for their respective funds. Blank music CDs and recorders, 17 U.S.C. A Section 1008 bars copyright infringement action and 17 U.S.C. A Section 1003 provides for a royalty of 2% of the initial transfer price for devices and 3% for media. The royalty rate in 17 U.S.C. A Section 1004 was established by the Fairness in Music Licensing Act of 1998. This only applies to CDs which are labeled and sold for music use. They do not apply to blank computer CDs, even though they can be used to record or burn music from the computer to CD. The royalty also applies to standalone CD recorders, but not to CD burners used with computers. Most recently, portable satellite radio recording devices contribute to this royalty fund. Thanks to a precedent established in a 1998 lawsuit involving the Ryopi MP300 player, most MP3 players are deemed computer peripherals, and are not subject to a royalty of this type in the U.S. Currently, private copy royalties are generated in the U.S. by the sale of blank CDs and personal audio devices, media centers, satellite radio devices, and car audio systems that have recording capabilities. United Kingdom Currently there is no proper private copy exception in the United Kingdom, there is only a narrow exception regarding broadcast time shifting of the Copyright, Designs and Patents Act 1988. On January 6, 2014 the UK implemented Art. 5(2)(b) of the Enforcement Directive by introducing a limited private copy exception. In fact, the Copyright and Rights in Performance Regulations 2014 provided an exception limited to the personal use, to the owners of a personal copy and with the exclusion of the even indirectly commercial uses. No compensation was provided. Indeed, the government took the stand that levies or other compensation are neither required nor desirable in the context of a narrow provision that causes minimal harm. Levies are an unnecessary and inefficient tax on consumers. They are unfair to consumers in that they are payable regardless of the use to which a levied device is put and regardless of whether a user has already paid for the copies they store on a device. Furthermore, particularly in the current economic climate, it is not right to extract more money from the pockets of hard-pressed consumers. Notwithstanding the long process of consultation and all the empirical evidence gathered, the British Academy of Songwriters, Composers and Authors, the Musicians Unregistered Trademark Union, and UK Music still found that this narrow exception harmed their interests. Therefore, they brought an application for judicial review and surprisingly succeeded. More precisely, on June 19, 2015 the High Court of Justice ruled only one issue in favour of the claimants, that was the submission that the decision was flawed because the evidence relied upon to justify the conclusion about harm was manifestly inadequate. This submission focuses upon the Secretary of State Unregistered Trademark's conclusion that the exception would lead to minimal or zero harm when the evidence relied upon does not support that conclusion. Legal scholars foresee that the private copy exception will be reintroduced, probably accompanied by a compensation scheme. See also, voluntary collective licensing. References: WIPO, International Survey on Private Copying, Law and Practice 2013 pages 4, A Levy was first introduced in Germany in 1966. Texts adopted, P7TA, 2014, 0179. Anticube Vitorino's recommendations of January 31, 2013 resulting from the latest mediation process conducted by the Commission in respect of private copying and reprography levies. In Good Company. Michael Geist. February 14, 2007. Retrieved April 16, 2008. Recording Industry's Digital Strategy Out of Tune. Michael Geist. February 19, 2007. Retrieved April 16, 2008. Belgian Official Journal P55-57. December 10, 2009. Retrieved January 16, 2010. Canadian Private Copying Collective v. Canadian Storage Media Alliance, 2005, 2 FCR. 654, Apple Canada Incorporated v. Canadian Private Copying Collective, 2008, FCJ. Number 5. http://cpcc concurrent tariff htm. Tekaja currency no Laki, 26a section, TO*Y. The other 4 EU member states lacking a private copying levy are Cyprus, Ireland, Malta and the United Kingdom. Greece has a private copying levy scheme in place, but does currently not enforce it. Beschluss vom September 23, 2008 Betreffenden Gemeinsamen Tarif for C. September 23, 2008. Retrieved January 12, 2014. Beschluss vom November 18, 2010 Betreffenden Gemeinsamen Tarif for D. November 18, 2010. Retrieved January 12, 2014. Beschluss vom 1. Mai 2012 Betreffenden Gemeinsamen Tarif for D. May 1, 2012. Retrieved January 12, 2014. Beschluss vom 23. February 2009 Betreffenden Gemeinsamen Tarif 12 inches. February 23, 2009. Retrieved January 12, 2014. Leadskommission Genehmiger Heberetsvega 1/4 tongue of music hands. March 22, 2010. Retrieved January 12, 2014. Quarterly Statement of Account. http://wp.archroyalties.com, Ginoto la DIEGA, in light of the ends. Copyright History Cis and Private Copy Exception after the British Academy of Songwriters, Composers and Authors and Others v Secretary of State for Business, Innovation and Skills case, forthcoming in Quadrini di Diritto Mercato Tecnologia, 2015, 2. External links, Copyright Act of Canada, Copyright Board Canada, Canadian Private Copying Collective, Copy Swede, the Finnish site for private copying levy.